Well, thank you very much for that introduction. I think the form that we've agreed for this evening is that I'll say a few words and then I'll join your president and allow any questions on pretty well any topic relevant to what I do, not only from the president but also from everybody here. It's a great pleasure to be back in the Oxford Union. It's almost embarrassing to have to tell you how long ago it is since I left Oxford, but as I'm very straightforward and honest, I will tell you it's 41 years ago. And I'm a life member of the Oxford Union until a few years ago when I changed my wallet for the first time in nearly 40 years. I carried my life membership card around with me. And only once in the last few years did I think I might come here when I was in Oxford. And I had arrived very early and I thought I'll pop into the Union and have a drink. But you've turned it into a fortress now. So without the right electronic card, I wasn't able to get in. So I used to come to the Union a great deal. I was not active in the Union, but came for the debates every week if I could. And also there were meetings of this sort in this room, but rather fewer than I understand you now have. And the last one I remember attending was Sir George Salty, a very famous conductor who was then not a young man, it has to be said, and he talked to us in here. But perhaps for just 2 or 3 minutes, you might like to know how I end up as Lord Chief Justice, having started as an undergraduate reading law at Pembroke College in just the same way that a number of you, many of you, I know are first-year undergraduates reading law. I mean, I guess like many of you, I found myself when I was 17 sitting around with my parents around the kitchen table, and they were giving me the "what are we going to do with you" talk that many of you may have experienced. And at school, a number of the masters had suggested that the law might suit me because I was actually reasonably argumentative. That seemed to be the first criterion, but also they thought that I was not too bad at analysing material and being able to produce something coherent, having done so. So the first question was whether to read law, and I decided to read law, and I did Oxbridge entrance at the end of my 4th term of 6th form at school, a young man in a hurry, some would say. And to this day, I have to say I regret not reading history, which is what I would love to have read. And I still kid myself that perhaps one day, after I've retired from this job, I might yet do a history degree. I don't suppose I could get in now, but I'll do my best. And so I read law at Pembroke and went straight from reading law to doing the bar exams, and from there to pupillage in chambers which kept me as a tenant, and in which I practiced for the whole of my career at the bar. My practice was in common law and public law, as you've heard, and that is what interested me because it involves dealing with really practical problems. It involves dealing with people a lot, and certainly the public law enabled me to get involved in a lot of cases which were at the heart of the controversial legal and political issues of the day. And as time went by, I was asked to join the Attorney General's panel of counsel, which in those days had only a handful of people on it, to deal with most of the government's public law work. Now there are dozens and dozens who do the work, and it gives you an indication of how the nature of that work has exploded. And after what seemed like a very long time in practice, but was only, I guess, 17 or 18 years, I took silk, became a Queen's Counsel, which was in truth the only real ambition I had when I was at the bar. And I was fortunate when I was in silk, when I was a Queen's Counsel, to do a lot of really, really interesting cases, a lot of the big public inquiries that were going on at the time, and quite a lot of the big public law cases that were going on. But it was pretty exhausting stuff. And so after about 8 years in silk. My wife said to me, this can't go on forever, and you've got to think of trying to do something different or complementary. And so it was really she who said, look, if they'll have you as a High Court judge, why don't you try doing that? And the time had come when, as with so many who have the good fortune to prosper at the bar, the time had come really to think about giving something back, which is part of what being a judge is all about. So I became a High Court judge in 2008, so nearly 12 years ago. I'll have my 12th anniversary on May the 12th. I remember the day extremely well. I had a wonderful time as a High Court judge, doing an enormous range of work. So I was in the Queen's Bench Division, which meant I sat in the Administrative Court, Court of Appeal Criminal Division, did big civil cases, tried high profile and difficult murder cases out of London. And it was a hugely satisfying existence. And then after that, doing that for just about 6 years, I went to the Court of Appeal, and after 3 years became Lord Chief Justice. And so what is the job of Lord Chief Justice? We might have questions about that, I don't know, but just in general terms, I'm head of the judiciary in England and Wales, and that means I'm responsible for and lead all of the judges in the criminal, civil and family courts. So that's the Court of Appeal, the High Court, the circuit judges and the district judges, total of about 14 or 1500. There are also many thousands of part-time fee-paid judges. The system in this country is to encourage successful legal practitioners relatively early on, by which I mean when they're about 40, don't laugh too much, but relatively early on in judicial terms, to think of becoming fee-paid judges to sit for a few weeks a year, trying cases in the Crown Court, that's criminal cases, or in the High Court, or in the County Court, or the Family Court. And that way we all did it, or pretty well all of us did it, and we discover whether we like being judges, and the system discovers whether it likes the person concerned being a judge, quite an important thing. And so I have responsibility for all of that, and about 14,000 magistrates. And one of the important parts of my job is to be responsible for the interaction between the judiciary and the executive, something which has become more of a topic of interest over the last year or so than it hitherto had been. So that's just a broad thumbnail sketch of what I do and how it is from sitting, not quite, the chairs look new.
Yeah,
I might say the books aren't, these are exactly the same. And upstairs, the books are the same, I remember some of them. But it's how I came from being where you are, which to me seems like only yesterday. It's an absolute truism that it doesn't matter how long you've been doing something, you always feel the 22-year-old you were when you started doing it, and you'll all feel exactly the same. But it's how I've come from where you're sitting to what I'm now doing.
Thank you. Thank you so much for joining us here today. You spoke a bit in your remarks about what you do, but going into that in a bit more detail, can you tell us about what an average week as the Lord Chief Justice looks like?
I'm not sure that there is anything quite as simple as an average week. I mean, the Lord Chief Justice is the head of the judiciary in England and Wales, and therefore must obtain authority from being a judge. There's an enormous amount of administrative work that I have to do, and also work in liaising with government and with regulators and all sorts of people and bodies whose activities affect what goes on in the courts. But my first job is as a judge, and so my average week involves sitting in court for a couple of days. At the appellate level, most judges sit for 3 days, and read and write on the other days, I tend to sit for 2 and have not quite as much time to read and write as I would like, and that often comes at the weekends. But that's at the heart of it. But otherwise, I spend time chairing the Judicial Executive Board, which is the governing body of the judiciary. We meet every week in one form or another. I chair the Judges' Council, which meets less frequently, but is a body comprised of judges from every level in the country that discusses issues that affect the judiciary, and they effectively provide advice to me. I meet government ministers, particularly the Lord Chancellor, Secretary of State for Justice, very frequently, the Attorney General, the Solicitor General, the Director of Public Prosecutions, and so on and so forth. And also have to engage a great deal with the Judicial Appointments Commission, and, as I say, all the regulators. So it's a pretty full-on type of existence.
You also touched on the ongoing discussion about the interaction between the judiciary and the executive. What do you see the role of the judiciary as being, or what it should be within society?
Okay. Well, now, I suspect that we have a real mix of disciplines here. We'll have quite a lot of lawyers, I don't doubt. I know PPE is your subject, and I've met 1 or 2 others who do something different. So forgive me if I'm making this too basic, but we have in any constitution governed by the rule of law, there are 3 essential pillars. There's the executive, there's the legislature, and there's the judiciary. Now, Alexander Hamilton, famous now for the musical, but more famous as quite a serious legal and political philosopher in his day, made the strikingly correct observation that whilst you have 3 pillars of the Constitution, the judiciary is inevitably the weakest, because we rely upon the other 2 pillars of the Constitution to enable us to function. We need Parliament to vote the money that the executive then allocates for the administration of justice. We need, in the end, the help of the executive to enforce our orders. I mean, happily, almost all the orders made by judges in any court are simply obeyed, because we live in a society governed by the rule of law, and not very many people just ignore what judges say. But occasionally you need the executive to enforce them. So the judge's job is to uphold and administer the rule of law. It's to interpret the law. So Parliament makes most of our laws, although, as you know, there's a large body of law that's made by delegated legislation that Parliament doesn't scrutinise in any great detail. But it's for judges to interpret the law. And crucially, in any society governed by the rule of law, the executive itself and the powerful, so the public corporations, the big private corporations, the trade unions, everybody, the powerful, must be subject to the rule of law just as much as the suspected criminal who's arrested and brought before the courts, or the parties to a family dispute that's unfortunately gone wrong. And so a critical part of what the judiciary does and has always done is to ensure that those exercising public power do so within the legal ambits that their power occupies.
And then going off of that, what do you think the interaction between the judiciary and the executive should be, and what role, if any, should judges play within the political sphere?
Right. Well, there are 2 parts to that question, if I may say so. The first is that it's absolutely critical to the smooth running of any society governed by the rule of law that each of the 3 pillars respects the other and respects the sphere within which the other operates. And so, as I've said on a number of occasions publicly, the judiciary must respect the proper sphere of activity of the legislature and of the executive. And both the legislature and the executive must respect the sphere of activity of the judiciary. Now, the second part of your question, should judges be political? Absolutely not. None of the decisions any of us makes is political in the sense that I think you're using the word. Inevitably, particularly in the area of public law, of judicial review, we're called upon to make decisions which have a political impact because they are concerned with policy decisions and sometimes quite important policy decisions of government. So inevitably, to that extent, we are concerned with things that are political in their outcome, but we are not political ourselves. And you will, I think, find it extremely difficult ever to work out what the private political views of any judge might be. And we really are trained to leave whatever our private views might be at the door when we go into court. We look at these problems purely through a legal lens.
In your time in the judiciary, how have you seen it, if at all, evolve through the many years that you spent working in it?
Well,
if you have seen it change at all.
Yes, well, I think not just in the time I've been a judge, which is 12 years as a salaried judge, and I sat as a part-time judge for 10 years before that. But in general terms, I think what's happened is that society has become very much more complicated in a legal sense. Now, I mean, I feel for the law undergraduates and the BCL students and the MPhil students here who have to grapple with a complexity of law which, when I was an undergraduate, simply didn't exist. And the law, mostly through legislation and delegated legislation, has found its way through the capillaries of life. And so an enormous amount of activity is now regulated by law, which simply wasn't 15, 20, 30, 40 and more years ago, with the result that there's more scope for disagreement and for challenge. So take really mundane things rather than the high powered things. In our tribunals, there are literally hundreds of thousands of cases a year relating to social security and the entitlement of individuals to what objectively may be thought to be relatively small amounts of money, but to them are absolutely critical for their existence. There are hundreds of thousands of those cases every year. Now, when I was an undergraduate, there was a mechanism for challenging social security, but the whole system was much simpler. So that's an example of where the law has just become more and more complex, and the scope for the citizen to rub up against the state has expanded. So too the immigration tribunal, which deals with, I can't remember the precise number, but many tens of thousands of cases a year. Again, that's completely different from how it used to be. And that, I think, is what has changed more. And that's why we now have so many lawyers. I mean, the number of people practicing law in this country has gone up exponentially since I started. The number of judges has increased phenomenally in the last 15 or 20 years. And it's just a reflection of how much the law, through regulation and legislation, has seeped into so many parts of life which it used not to.
A lot of industries are already being impacted by developing technology and AI. Do you see AI having any impact on the functioning of the judiciary in the future? And sort of as a second part to that question, where do you see the judiciary in British society in 10 years from now?
Okay. Well, now, AI is something which fascinates me. And the law can't be left behind. I mean, there is a bit of a myth that lawyers are all rather fusty individuals who sit in little offices surrounded by dusty books, but that's just not the way things operate nowadays. And as the whole of the way the world works changes, so too the way the law works, the way lawyers work, and the way judges work. So, for example, I set up a group of experts to advise me on AI and the judiciary, to ensure that as things change around us, we're not left behind and caught out. So I want to be looking forward. Now, AI is a term that gets people very excited sometimes, but it shouldn't, because it's just a development of the ability of machines to do things that we all used to have to do ourselves. But in terms, for example, of analysing documents, the time will come, and it may well be with us already in some places, where it will be possible to search hundreds of thousands or millions of documents efficiently, effectively, adequately, and almost instantly using AI. The sort of exercise that in the past a law firm or a commercial organisation might commit 20 or 30 trainees to and stick them in a warehouse for weeks on end. I mean, that's what used to happen. So this is the sort of thing that is going to happen. There are some very interesting and not altogether necessarily welcome potential developments. For example, the analysis of judgments by AI to try to predict outcomes. Now that's happening a lot in the US already. In France, they've banned it. They just say you can't do it. And it's coming in this jurisdiction, because we make all of our judgments, certainly at the higher levels, available to the public for free. So this is happening already.
Would you agree with France's decision to ban the analysis of
I think it would be unwise of me to express a view on the approach of a friendly nation. I think we just have rather different approaches. The default position here, as in the US, is that information is public and people should be able to do what they like with it, but it's not without hazard.
On the topic of developing technology, how have social media and online journalism impacted the functioning of the courts, if they have at all?
Oh yes, they have in a number of different ways. One way which I'm very concerned about, because one of my responsibilities is for the welfare of judges, is the way in which judges now are subjected to abuse through social media. It just strikes me as extraordinary that so many people almost feel it doesn't matter what you put on social media. It's ephemeral in a way, and yet it's there forever, and it can often cause a lot of harm, not just upset. But if a public figure, and let's face it, public figures of all sorts, especially politicians, are subjected to constant abuse on social media. But if you're subjected to abuse which is threatening your family, for example, which has happened, it's no surprise if it has a really powerful impact sometimes on the people concerned. So that's one aspect which is a new development and an unwelcome one. It's also a feature now in evidence, particularly in the criminal courts. Not just social media in the sense I think you're using the term, but the constant electronic communication that people have with each other can often be of great importance in a criminal case, not just in enabling sometimes an offence to be established. So, classic example, if you're concerned with an alleged drug conspiracy, being able to see who's been contacting whom not what they said, because that's not kept, but your phones keep a complete record of everything you've ever done. And so that can help produce a picture. But also, and you will all know this from the notorious cases that there've been, in those terribly difficult cases involving alleged sexual offences especially, where in the end it's one person's word against another with very little, if any, outside evidence which enables people to pin their thinking, then the exchanges by phone or by other media can be of great importance. So that is affecting. And the last area I'm perhaps mention is one that causes concern, but in the criminal court we try to deal with firmly by direction. That is jurors making private investigations of either the people involved in the case or the circumstances surrounding it. And so in all criminal cases now, jury cases, the juries are given a very strong direction that under no circumstances must they make any private inquiries on the internet of matters relevant to the trial. And again, just even in my time as a judge, the change. When I started as a recorder, a part-time judge in the Crown Court over 20 years ago, one would solemnly say to the jury, you mustn't go and look at the scene of the alleged crime, or you mustn't go to the library and look up anything about it. You know, you just think we're living in a funny old world. Whereas now, I think there is a real problem, because unless you tell people not to, it's the instinctive thing, isn't it? You have all your guests coming through each week. Now I'll bet that an awful lot of people who turn up here to see your guests will have done a 2-second Google, and that's how everybody operates nowadays. So we do need to warn juries about that.
And while we're discussing the evolving judiciary, it has been criticised for a lack of diversity. Where do you think it's at right now, and what steps do you think still need to be taken to promote inclusion and diversity within the judiciary? Well,
now, first of all, I've spoken quite a lot on diversity in the judiciary, and the first point that I would make is that recruiting the judiciary at every level from the widest pool of qualified lawyers is likely to enhance the quality of the judiciary. The Judicial Appointments Commission appoints judges on merit. And so one thing that I've always felt it quite important to nail is the notion, I've never heard anyone actually say it, but there's a suspicion that people think it, that diversity is the enemy of quality. On the contrary, diversity enhances quality. And the second thing about diversity is that it also enhances public confidence. Now, as it happens, the judiciary still enjoys a really high degree of public confidence. Some of you may have seen an article in The Economist last week, which was talking about the supposed clash between judges and the executive. But one of the points it made was that the latest survey suggests that judges have the confidence of 81% of the population. Now, it would be indelicate of me to go on to tell you the figure for politicians, but it wasn't anything approaching that. So that's why diversity really matters. The judicial profession in England and Wales and in Scotland and in Northern Ireland is a second profession. So everybody starts as a legal professional and then comes to the judiciary later in life. So the judiciary relies upon the legal profession for its people. And one of the realities of life at the moment is that the legal profession, particularly in its most senior ranks, both at the bar and in the solicitor's profession, is not as diverse as it should be. And so we have a pipeline problem, put it in simple terms. But despite that, enormous progress has been made. Now, we've not made the progress that we need to make. The proportion of women in the judiciary has grown very significantly. In the tribunals, it's now, I think, more than 50%. It's not there yet in the courts. It is in magistrates, for example, well over. But the problem is at the very top, where for women we're at about 25% at the moment. And all of us would like to see that percentage increase. But our problem is that the legal profession, from where we take our judges for the senior positions, is not as diverse as we would like. And whilst progress has also been made with ethnic minority judges, one of the realities that we have to face is that let's just think about the High Court. So most people who are appointed to the High Court are appointed at 50 or above, a handful before 50, a few beyond 60. So the people who are being appointed to the High Court today were undergraduates 30 years ago. And so you have to look back at what the composition of undergraduates and people in universities was at that time. And then if you look at the even more senior ranks, people of my sort of age, it may appall you for me to remind you that it was the year I left Oxford, 1979, that most of the colleges went mixed. Before then, most of the colleges were male only. And so, these are the realities of the pipeline that we still have. But the progress has been really striking, more striking for gender than ethnicity, I'm sorry to say, but progress on both fronts. And there is an enormous amount of work being done, not only by the judiciary, but by the professions, the Judicial Appointments Commission, all sorts of people, to try to make continued progress.
Thank you. My next question is a bit of a broad one, but I was wondering if you could tell us about some of the most impactful cases you've seen as your time as Lord Chief Justice.
Well, I mean, one of the joys of being Lord Chief Justice is that I sit on a lot of really interesting cases, not least because I'm able to choose all the cases that I sit on if I wish. But just to give you a sort of idea of the flavour of the variety of cases. Just since the beginning of the year, a fascinating, or at least fascinating to me, case about the scope of parliamentary privilege in the context of the publication of a report into child abuse, a case called Warsama. A recent case about expenses in the EU referendum. I had to decide a case about whether body modification, I'm looking at the room, you probably all know what I mean. When I first read the case, I'm afraid I didn't quite understand the extent to which some people wish to modify their bodies, but this was unqualified people doing body modification by cutting off ears, removing nipples, doing all sorts of things that it would be not so good to go into now. So the question was whether the fact that somebody had apparently consented was a defence to a count of serious, well, the lawyers are nodding, you've probably had the misfortune of reading my judgment. But that was fascinating. A good example of the vitality of the rule of law. Last year, I heard the appeal of Tommy Robinson against the contempt finding that was made against him in a Crown Court. Now, we allowed that appeal, and it was reheard, and in fact, he was found in contempt again, but by a process which satisfied legal fairness and so on. So those are just, but there's dozens of cases over the last 2 or 3 years which have given me a great deal of interest and stimulation.
So you said that when you first read the body modification case, you weren't quite sure of the extent to which it that it covered. How much research and preparation goes into every case for you? And you must have an incredibly hectic schedule. So how does that work for you?
Well, essentially, we rely on the materials that are put before us by the parties. Dealing at the appellate level, you have obviously the judgment below, and also all of the materials that were before the first court, and if you're sitting in the Supreme Court, then two levels, and arguments from counsel, supported by authorities, so legal authorities, but not only legal authorities, but often all sorts of academic and relevant information. So on the body modification case, I can't remember precisely what we had, but we certainly had a good deal of academic writing on it, which explained how it worked and so on. So yes, it's a good learning curve always. It's always something I say that people think I'm not quite sure why that judges are out of touch. I don't know why we should be any more out of touch than you all are, because after all, we were you once. But the truth is that in the course of most judges' lives, particularly those who sit in criminal cases and in family cases, I can assure you that we see more than most people will ever encounter or would like to encounter.
My final question before opening this up to the audience is, going back to your work before Lord Chief Justice, you acted on the inquest after the death of Princess Diana. Can you tell us a bit about what this was like and what your biggest takeaways from this were?
Well, again, I'm just thinking of the perspective of time. The crash in Paris that killed the Princess of Wales, Diana, and Dodi Al-Fayed happened in 1997. A large number of those in this room will not have been born in 1997. It then took 10 years because of the investigations by the French authorities into the potential criminal liability of some of those involved, and also an enormous investigation here into all sorts of allegations that turned out to have nothing to them. But that was the reason why it took 10 years before the inquest could start. And I was leading counsel for the inquest itself. So that my role and the role of the team of counsel I led was to lead all the evidence in the inquest, and also really to make sure that everything was explored that needed to be explored. And this is sort of ancient history for you, really. I'm just trying to put it, sort of have in my mind a comparison. So if this was something that had been asked of someone in my first year as an undergraduate in 1976, be looking back to 1953, which before I was born, I might say, the coronation of the Queen. So I appreciate that this all will sound like ancient history to many of you. But what was floating about was a massive number of inconsistent conspiracy theories. Now, the problem with conspiracy theories is that for those who like conspiracy theories, the fact that you can find no evidence in support of the conspiracy theory itself is evidence in support of the conspiracy theory. And we were dealing with conspiracy theories, all which started from the premise that someone in authority was responsible for this crash. And then there were about 10 different completely inconsistent theories as to how it could happen. So some of them were more far-fetched than others, but in the end, all of them were far-fetched. And what was fascinating about the process, we decided first that we would explore every single one of them. every single one of them, and we called all the evidence. And an awful lot of these people who had been given the oxygen of publicity over many years, so they'd given TV interviews and unchallenged, just able to say what they thought happened or what one or two of them thought they saw. But get them along to a hearing, a jury, a quite wonderful jury, not a single day lost in 6 months through that jury. They were quite remarkable. But expose these witnesses just to the gentlest of polite questioning, and so much of it just fell apart. And at the end of the process, the jury, having heard it all, returned a verdict which confirmed what many had long thought, namely that this was a terrible accident with a number of immediate and slightly remote causes. But what I took from it was, first of all, the value of oral testimony. Now, it's absolutely underpins the way we do law and litigation, not just criminal, but also civil litigation in this country. And the value of it was brought home to me, if ever it needed to be, by that. And also the value of having juries make controversial decisions in an environment like that, and so too in criminal cases, because if we had gone through that process for 6 months with just a single judge deciding, at the end of it, those who were inclined to believe the conspiracy theories, whatever evidence was deployed, would say, well, they're part of the conspiracy. But a jury brings the whole process a validity which single judges don't. And I think that's why, should there ever be a suggestion that we should do away with juries in serious criminal cases, I would continue to argue that it's good to use them, because it inspires confidence in the results.
Thank you. We will open this up to the audience now. So if you have a question, please raise your hand, wait for the microphone to come to you, and please stand up while asking your question. Could we go to the hand in the red in the back of the room?
I'm interested in your views about secrecy in the family court, whether you think it should be a more open process and the risks of that for professionals as well as families.
Yes. Well, can I start by picking you up on the use of the word secrecy? There is privacy in the family courts, and privacy and secrecy are very different things. And one is not a synonym for the other, I would respectfully suggest. Now, in the family courts, there are some statutory prohibitions on completely open justice. And as you know, over the last few years, there have been great strides made by the judges, in fact, to open up the family courts to the extent that it's possible. And that is a process which I support unequivocally. So I think open justice is vital. Open justice, that's to say, having the ability of the public and the press to attend as many hearings as possible, improves the quality of what goes on in our courts. Publicity is the best antiseptic, as was it John Stuart Mill who said that? It was somebody who really knew what he was talking about, and I should know. But that is undoubtedly true. And so I think for that reason it's important, and also it encourages public confidence. If through the press often they know what's going on. But in the family courts there is a particular issue which is different from the issue in other courts, and that is that an awful lot of what the family courts have to deal with on any view is private. It can be private between adults, but even more importantly, so much of what the family courts do is concerned with the welfare of children. And exposing to public scrutiny the workings of dysfunctional families to the detriment of the children is something we obviously have to guard against. So to come straight back to the heart of your question, do I support openness in the family courts? Yes, so far as it is possible to do it consistently with respecting the privacy of those involved. And also I think we have to recognise that for some further strides to be made, it will be necessary for the executive and then Parliament to look at one or two of the underlying statutory provisions, all of which you will know inside out, but I'm not here to give a law lecture.
Could we go to the member in the middle? Yeah.
The Supreme Court, so I can hear you, the Supreme Court unanimously found that the prorogation of Parliament last year was unlawful. You heard the matter originally and got it wrong. Why was that?
Okay, well, now one of the cardinal rules of judicial behaviour is that we don't comment on our own judgments beyond what's in them, and we don't comment on other people's judgments. And I think all I would say is that on any view, the law was quite substantially developed by the Supreme Court.
Could we go to the hand again in the middle, just on the other side?
In 2017, a report on the Aarhus Convention said that the UK was non-compliant in terms of the access to justice pillar. I just wondered if you thought it was an access to justice problem and how we'd like try and overcome it.
Okay. Well, now I'm not familiar with the particular instance you give relating to the Aarhus Convention, although, as you will know, the Convention provides, amongst other things, for particular costs regimes to apply in environmental cases. And so far as I am aware, but I stand to be corrected, if not immediately, please, but at some point, the rules of court that were introduced reflect the requirements of the Aarhus Convention. So far as access to justice is concerned, there is an enormous amount of work going on to try to make justice more accessible for those who wish to vindicate their rights through the civil courts, and also to make it easier for people to resolve their problems through the courts when necessary in the family environment. Now, in the civil context, part of the problem identified by many commentators is that civil process is too complicated, and it is especially too complicated given sometimes the relatively small amounts of money that individuals and businesses need to argue about. And I think that's right. Now, one of the solutions is to make it easier to vindicate one's rights, so litigate, using simple online procedures. And there's a huge amount of work being done at the moment to develop simple online procedures in the civil context. There's something called the online money civil claims procedure, which at the moment is limited to claims, I think, up to £10,000, but forgive me, I haven't got all the detail in my head. But that is proving to be very successful. It is popular, and it is, we think, expanding access to justice. And so I'm very keen that we should continue with that. Another example, although it's not a happy example, is the availability now of online divorce. Now, this is something, it's quite extraordinary what happened. Filling out divorce forms, you might think would be straightforward, but something like 40% of those filled out by people doing it themselves had to be returned because they got things wrong. They could, of course, pay lawyers to fill out the form for them, but for good reason, many people don't want to do that. They can't afford it. So now it's possible to do it online. It's much quicker to do it online, and only 0.5% or 1% have to go back because they're wrong. And that's because on any online system, just as we all encounter when you're trying to book something online or do anything online, if you don't get it right, the wretched thing tells you, no, you haven't filled in this mandatory bit. And that's how these work as well. And so that is another example of how things are being made easier. Similarly, in the tribunals, the Social Security Tribunal and the Immigration Tribunal, there are projects going on at the moment with pilots to introduce online process. So to tax, I mean, you may think it's not a big issue, but if you've got a tax bill and the revenue have told you you've got to pay 2,500 and you think it should be 1,500, well, then you appeal to the tribunal, and now that can be done online, and so on and so forth. And this is coming. It's coming quite slowly. It's not as straightforward as you might think, but we're absolutely committed. We, the judiciary, are absolutely committed. So too is the government to making the courts easier to have access to, and that's vital for access to justice.
Could we go to the member in the third row, at the end of the third row here?
Hi. Just wanted to ask you what you think the relationship between parliamentary sovereignty and the rule of law should be, especially in situations where they might seem to be at odds with each other. So, for example, if Parliament tried to hypothetically pass a statute that would criminalize certain conduct and tried to apply it retroactively, or passed a statute implementing severe financial restrictions to access to appellate courts.
Yeah, well, certainly so far as the UK is concerned, Parliament is sovereign. So at least in theory, Parliament can pass any law it chooses. Now, there have always been constraints on that. I mean, one of the constraints, and all the lawyers here will know it, is that Parliament has not been able to pass laws that are incompatible with EU law, and a mechanism was devised which enabled judges not to apply incompatible EU law. Parliament tries to legislate in a way which is never incompatible with the law of the European Convention on Human Rights. And every bill that's presented to Parliament by a minister carries what amounts to an assurance that the minister is satisfied that the legislation in question does not contravene the European Convention on Human Rights. Now, judges can't quash legislation, but as many will know, there is a mechanism which was introduced by the Human Rights Act 1998, which enables judges to say that a piece of legislation is incompatible with the convention, and then it's a matter for the executive and Parliament to put it right if they wish to do so. Now, it's always possible for people to theorize about, what would the judges do if Parliament passed a law and then they give some absolutely dreadful, extreme example of something which was quite terrible. The question is, well, then surely the judges should strike the law down. Well, we can't do that in our constitutional arrangements. And I've always found the theoretical debate of that a little unreal, because, I mean, the sort of examples that are used are notorious examples from history. But they're unreal, because if you ever found yourself in that position, the notion that if Parliament passed some extreme law and somebody invited a court to strike the law down, and the court was persuaded to overturn hundreds of years of constitutional theory and do so, well, then you've really moved into an environment where is what the courts say going to make any difference anyway? I think there isn't the conflict that you think of, and I appreciate that in at least 2 instances, judges have mused about the possibility of the courts declaring primary legislation to be unlawful by reference to some higher norm. But those were musings, and along with almost all of the judiciary, I simply don't agree with them.
Could we go to the member in the 5th row? Yeah.
Do you think that there's an issue with justice not being valued enough in the UK, if you consider the condition of large portions of the legal system being woefully underfunded, courthouses themselves being often difficult places to work in and be in? And how do you think that may change over time? Or do you think a larger shift is required in perhaps public perception of the system?
Yeah. Occasionally, I talk to people who were involved in the justice system many decades ago and before, I mean, my early years, but beyond, my predecessors, who I see a lot. And they always say, look, you mustn't think that there was ever a golden age when the administration of justice was showered with money. It just never existed. But it's true that the problems have become more acute in recent years because after the financial crash in 2007, 2008, the Ministry of Justice and thus the court service and the administration of justice generally was not a protected department. And departments that weren't protected suffered greater restrictions on funding than those that were protected. So there is no doubt that the consequence of that has been to leave quite a lot of the court estate in particular in a pretty depressing condition. Now, that's not to say that we don't have some terrific buildings. We do, and some that have been built and opened in the last 10 or 15 years. But the reality is an awful lot of our buildings are in a really less than good condition. And I've said publicly before that I think 1 or 2 amount to an embarrassment. They're so awful. Now, putting that right is going to cost a great deal of money. And part of my job is to make representations and try to persuade the government to provide additional funding to support the administration of justice. Now, it's a long process, it's a slow process, it's paying some dividends, but I think it will be quite a few years yet before some of the shortcomings that we've had over recent years are made good.
Unfortunately, that is all we have time for today, but please join me in a huge thank you for this event.